Welcome to the Tejswi IP Show. In this podcast, we dive into the world of intellectual property, like patents, copyright, trademark, geographical indication, design. Also, analyze the recent event in IP world. Today, we're zeroing in on something I think, well, pretty much every creator, marketer, maybe even just folks browsing online have bumped into. You know that feeling. You find an amazing image or great sound clip, maybe a video, and you think, wow, I want to use this. But then that hesitation kicks in. Am I allowed? It's like this huge online buffet of content, but you're worried about getting slapped on the hand legally if you take something.
Exactly. And that's really why we're talking about this today. We want to try and, cut through some of that confusion, that maze of copyright law. We're going to look at some, legitimate ways, maybe even surprising ways you can actually reuse content so you can navigate that digital buffet with a bit more confidence. We've looked at some sources that really dig into these copyright exceptions, the ones people often misunderstand or even call loopholes, though that's maybe not the right word.
Okay, but before we really jump in, we have to add that standard but really important disclaimer. This comes straight from the material we reviewed. What we're sharing today, it's practical insight, it's information. It is absolutely not legal advice.
That's crucial. Yeah. Always, always talk to a licensed legal professional if you've got specific questions about your own projects or situation.
Right. Consider this food for thought. Maybe a starting point for your own research or that conversation with a lawyer. Okay, let's get into it. So where do we start? I guess with the big one, huh? Fair use. Our sources call it maybe the most misunderstood legal weapon.
Mm-hmm.
You've definitely heard the term, I'm sure. But what actually qualifies? It feels slippery sometimes.
It really does feel that way. And, that's partly because fair use isn't some simple checklist. It's a flexible doctrine, particularly in U.S. law. It basically allows using copyrighted material without getting permission, but only under certain conditions. Things like commentary, parody, criticism, news reporting, teaching, research. The whole idea is that some uses are just beneficial for society, enough to sort of override the copyright holder's rights.
Okay, but how do courts figure that out? What do they look at?
Well, they typically balance four main factors. First, the purpose and character of your use, like is it commercial? Is it transformative? That's a big one. Second, the nature of the original copyrighted work itself. Is it factual or highly creative? Third, the amount you used. How much did you take and was it the heart of the work? And fourth, crucially, the effect your use has on the potential market for the original work. Does it hurt the original sales?
Can you give us a concrete example? Like for someone making YouTube videos.
Sure. Let's say you're doing a movie review. You use a short, 15-second clip of a scene you're specifically talking about, critiquing the acting or the cinematography. You're not just showing the clip for fun, you're commenting on it. You're adding analysis, maybe transforming its meaning in the context of your review. That strengthens the fair use argument.
Ah, okay. So that pro tip we found makes a lot more sense now. The more you transform the original, give it a new purpose, new meaning, and the less you mess with its ability to make money, the stronger your case for fair use. It's really not just about how much you use, but how and why.
Exactly. Transformation is key. Are you adding something new or just copying? That's the question. Now, moving on from transforming content, what about content that's just free? Completely free. That takes us to the public domain. And this is where it gets really interesting for creators, stuff that's genuinely up for grabs.
Up for grabs sounds amazing. So what does public domain actually mean? Why is it such a big deal?
It means the copyright on the work has basically vanished. Either it expired, maybe it never had copyright in the first place, or the creator deliberately gave up their rights. So anyone, and I mean anyone, can use it, remix it, build on it, even sell it without asking permission or paying anything. Think old photos, classical music scores, really old books.
And our sources mentioned some great places to find this stuff, right? Project Gutenberg for literature.
Yeah, Project Gutenberg is fantastic for classic books. The Public Domain Review is another great one. They curate images, films, audio, all sorts of things.
And you mentioned government websites, too, like NASA.
Absolutely. Those incredible space images from NASA, generally they're in the public domain because they were created by federal employees during their work. Same goes for lots of reports, data, photos from other U.S. federal agencies.
Wow. Okay, but there's got to be a catch, right? A pro tip, maybe.
There is. The crucial tip is always double-check the dates and the specifics. Copyright terms are complicated. They vary by country when it was published. In the U.S., as a general rule of thumb, works published before 1929 are now in the public domain. That date moved forward recently. But be careful, a modern translation of an old book or a new arrangement of a public domain song might have its own new copyright. So check the source carefully.
Got it. So verify, verify, verify. Okay, so we have fair use, transformative, conditional, public domain, totally free. What's
Yep.
in between? What about creators who want to share, but maybe with some rules attached? That's Creative Commons, right? It's like creators saying, hey, here are my rules, come play.
That's a perfect way to put it. Creative Commons, or CC licenses, are basically pre-approved permissions. Creators choose a license that tells everyone how their work can be used without needing to ask each time. There are different flavors. Some allow commercial use, some don't. That's the NCI or non-commercial tag. Some require you give credit, that's BWAIA for attribution. Some say if you remix it, you have to share your new version under the same license, that's SA or share alike.
And finding CC stuff is pretty easy these days. Where should people look?
Yeah, it's gotten much easier. There's the Creative Commons own search tool, which is a good starting point. Unsplash is huge for photos, mostly under a very permissive license. Free Sound is great for audio clicks and sound effects under various CC licenses. Lots of platforms now let you filter for CC content.
Okay, but you mentioned different flavors. What's the big warning sign here?
The crucial warning: read the specific license. Don't just assume Creative Commons means do whatever you want. It absolutely doesn't. Like, CC BY means you must give credit the way the creator asked. Fail to do that, you're infringing. CC0 is the closest to public domain, basically. No rights reserved. But others, like those with NC, non-commercial, or ND, no derivatives, meaning no editing or remixing, have real restrictions. Using an NC image in an ad? That's a problem.
That NC one seems like a common tripwire. Okay, moving on. Time for something maybe a bit lighter. Parody and satire. This is where you can use copyrighted stuff to make fun of it, right? Our sources say this has real legal backing.
It does, typically falling under the umbrella of fair use, actually. The classic example everyone knows is Weird Al Yankovic. His whole career is built on taking hit songs and writing funny new lyrics that often mock the original song, the artist, or pop culture trends. Now, interestingly, he often does ask for permission, mostly out of courtesy and good industry relationships, but legally. For a true parody, he likely wouldn't have to, because it's transformative commentary.
That's fascinating. So the courtesy is extra, the right is already there. What's the key takeaway, the pro tip, for making a parody that's legally sound?
The key is your work needs to actually comment on or critique the original work you're borrowing from. You have to be in some way making fun of it or using it specifically to make fun of something else. It's not enough to just copy the style or vibe of something popular to make your own unrelated joke or product. That's probably just infringement. The humor or critique needs to target or at least clearly reference the source material.
Right. It has to be about the original in some way. Okay, building on that idea of changing things, let's talk more about transformative use itself. This feels like a really core concept. It's not just copying, it's making something genuinely new.
It really is central, and courts tend to look favorably on it. Transformative use is all about taking existing material and, well, transforming it. Adding new meaning, a new message, putting it in a totally different context. Think remixes, mashups, collages, using something ironically. It definitely overlaps with fair use, that first factor, purpose and character, but the emphasis is squarely on the newness you bring. Are you creating something that didn't exist before, using the original as raw material?
And Banksy is the prime example here, right? Using famous images, but twisting them to make a political point.
Exactly. Banksy takes well-known symbols, artworks, or cultural icons and completely recontextualizes them. He adds layers of political commentary, irony, social critique. It's not just reproduction, it's a powerful reinterpretation. That act of adding significant new meaning or message is what makes it transformative and often legally protected.
So for anyone listening, the question to ask isn't just, can I copy this,
But how can I transform this? What new perspective, what commentary, what unique expression can I add to make it something more than the original? That's where the creative magic and often the legal safety lies.
Okay, shifting gears slightly. Here's some good news, especially for folks in the U.S. Using government content.
Generally, okay, right.
Generally, yes, specifically for works created by the U.S. federal government. It's a huge resource many people overlook. Most documents, photos, reports, data created by federal employees as part of their job are automatically in the public domain in the U.S.
So that means those amazing NASA photos we mentioned, census data for reports, CDC health graphics for educational materials, all fair game.
Largely, yes. It's a vast repository of high-quality, reliable content you can often use without restriction for almost any purpose.
But there's always a but, isn't there? What's the caveat here? The main caveat is this generally applies to federal government works. It doesn't automatically apply to works created by state or local governments. Their rules can vary. And it also might not apply to work done for the government by outside contractors. Sometimes the contractor retains copyright. So, as always, check for any specific notices or licenses, especially if it's not clearly from a federal agency.
Okay, good to know. Check the source, check the fine print. Now, before we wrap up, we absolutely have to tackle a myth, a really persistent one, the 30-second rule for music or the 10% rule for text. Let's just bust this right
Oh,
now.
please, there is no such rule. No law says using under 30 seconds of a song or 10% of a book is automatically okay. It's completely false. Where this myth likely comes from is a misunderstanding of fair use. Yes, using a small amount is one factor courts consider.
But only one factor. Right, and probably not the most important one compared to, say, how transformative it is or if it harms the market.
Precisely. Relying on some arbitrary time limit or percentage is incredibly risky. A 3-second sample could be infringement if it's the iconic hook of a song and you're just using it without transformation. Infringement isn't measured with a stopwatch.
So what's the smarter alternative, especially for something like music?
The much, much safer route is to use licensed music. There are tons of great libraries now. Epidemic Sound, Artlist, even the YouTube audio library has free options. You pay a fee, or sometimes it's free with conditions, and you get clear rights to use the music in your projects without worrying about that infringement hammer dropping. Why risk it?
Makes total sense. Okay, so we've hit the legal ways to use content. Let's quickly list the big don'ts, the risky assumptions to avoid.
Right, the common mistakes. First, thinking giving credit makes it okay. Nope. Attribution is nice, sometimes required by a CC license, but it's not a substitute for permission or a valid fair use claim.
Okay, what else?
Second, believing if it's on Google Images, it's free. Absolutely not. Google finds images, it doesn't grant rights to use them. Most are copyrighted. You need to trace it back to the source and check its license.
And the really dangerous one.
Yeah, the I'll just use it till I get caught approach. Terrible idea. Statutory damages for copyright infringement can hit $150,000 per work. Not per use, per work. The risk is massive.
Wow. Okay, so let's quickly recap those 7 pathways we discussed just to make it super clear. Fair use. Is that a definite yes?
Nope, it's a sometimes highly dependent on being transformative or critical, judged by those 4 factors.
Public domain.
That's a solid yes. No copyright, just double check the work is truly in the public domain.
Creative Commons.
A yes, but you absolutely must follow the specific license terms. BY, NC, ND, SA.
Parody satire.
Yes, generally protected under fair use if it actually comments on or mocks the original.
Transformative use.
A strong sometimes. It's about adding substantial new meaning or purpose, often key to fair use.
Government content, U.S. federal.
Usually a yes, as these works are typically public domain. Watch out for state, local, or contractor works, though.
And finally, the short clip, percentage myth.
That's a definite no as a rule, or highly risky at best. Duration alone doesn't make it legal. Only strong fair use factors do. Avoid relying on this myth.
Okay, so for everyone listening, creators, marketers, educators, understanding, this stuff really isn't just optional, is it? These aren't like sneaky loopholes. They're actual parts of the law designed to allow for creativity and commentary.
Exactly. They're creative rights and flexibilities. And using them thoughtfully, understanding the boundaries, actually gives you more freedom to create, to share, to remix, innovate, without that constant fear of legal blowback.
So maybe a final thought to leave you with. The next time you see an image, hear a song clip, watch a video online that you admire. Pause. Think about what we talked about today. Can you start to see the difference now? The difference between something you just want to use and something you actually can use legally, ethically, and creatively. Making that distinction is pretty empowering. Thanks for listening. Stay tuned for more upcoming episodes.